Welcome back. Lesson number 3 of 10 in this series on administration. Why minutes, not money, protect the trust. This lesson explains why trustee learning sessions matter, are not optional, why minutes are legal instruments, not notes, and how poor record keeping quietly destroys the otherwise valid trust. In this video, we'll clarify why trustee learning sessions exist, why they must happen at least twice a year, and why the minutes from those meetings can either protect the trust or collapse it. Many trustees believe meetings are optional, informal, or something that can be caught up on later. When trustees don't meet regularly, the trust stops being a living administration and becomes a static document. Here's what usually happens. Trustee meetings aren't scheduled, decisions are made informally, no formal minutes are kept, memory becomes the record, and authority becomes unclear. Nothing looks wrong until it matters. Common law trusts operate by private contract, not by structure. That means authority is proven through conduct and record, not registration. Trustee meetings are the conduct that creates the record. A trust with modest assets but disciplined trustees is stronger than a wealthy trust with sloppy records. The meeting's minutes prove substance of the trust, and the substance outweighs the size of the trust. It doesn't matter how many things you have in trust, how much money you have in trust. If it's not recorded in the minutes, the decisions based on those things in trust, you're going to be in trouble. Here is one of those aha moments. Well, at least it was for me, and where the possibilities became clear. I personally have never seen a wealthy trust with sloppy records. I can, however, speak to sloppy records in a modest one. Trustees do not own anything. Let's be clear, they hold legal title and exercise control only through authorized acts. Acts that must be reflected in the indenture, which serve the purpose of the initial declaration and then in the minutes. A trustee learning session is a formal meeting of the Board of Trustees. If you are watching this right now and plan to settle a trust, that means you're going to be the grantor, the settlor, things like that. You should include in the indenture, trustees should meet either monthly, every 60 days, or quarterly during the first year. Then, depending on trust activity, the meeting times could decrease or increase the next year. Here's a side note. Organizing minute meetings are trust officer responsibilities. If you're unsure of what a trust officer is, go watch How to Start a Trust and become your own general manager. Both links linked in the description. These learning sessions exist to learn the trust purpose, align trustees with their duties, review administration, and confirm decisions were made lawfully. Trustees become competent. Minutes are not summaries. They are legal records. They serve one function: to prove what was done, by whom, when, and under what authority. Okay, now don't get discouraged. It's not a lot. This is a dense subject. And on this channel, you will learn in plain language how to set up and manage every aspect of a trust. Now let's keep going. Equity is judged by substance. Substance is proven through declaration. Why was the trust established? The trust indenture. What is allowed? And the minutes. What actually occurred? If the minutes demonstrate that trustees acted within their authority, understood their duties, and followed the trust purpose, equity stands. There is plenty of case law to support this. However, just in case you want to read up on a frequently cited case, check this one out. It still holds true to this day. Courts examine records to determine true operation of trust. Remember, the United States Constitution declares no state shall pass any law impairing the obligation of contracts. U.S. Constitution, Article 1, Section 10. Take that in. You, by contract, not by fraud, by contract, voluntarily and honestly contract with your trustee to meet X amount of times during the year. And these meetings stand as your source for evidence of substance, if needed. That being said, now no state can undo what you've created. Careless minutes or missing minutes invite claims that the trust is a sham. This is why recording minutes is not easy beginner work. However, it is doable and gets easier with practice, just like anything else. You may be watching this as a trustee learning your responsibilities, a settlor ensuring trustees are properly trained, a beneficiary concerned about administration, or an exchanger relying on trustee competence. Imagine looking forward to all the videos teaching you how to set up and manage your assets in a private trust. strategically managed by a trustee for the benefit of your beneficiaries, and you're not subscribed. Do you have commitment issues, dog? Subscribe. It's free to subscribe and hit the notification bell so YouTube cannot decide when and how you see the next video. It's free. Remember, trustee learning sessions are not an optional social opportunity. Trustees meet, learn, and record properly so the trust demonstrates life, intent, and a lawful operation. This is how trusts remain quiet, lawful, and durable. Not loud, not aggressive, not visible, just effective. Think differently about meetings and records. They are not chores. They are shields. If this helped clarify how trusts are meant to function, like the video. Subscribe to this one-of-a-kind YouTube channel because this knowledge is life-changing, and I don't see a lot of channels putting it down like this. I'm just being honest. You're not going to get this type of information distilled down and delivered in this way nowhere else but on Wealth Locked In, so subscribe. Everything here is built for clarity, privacy, and precision, so you can move forward with confidence. Since you made it this far, I suggest that you watch this video next. I'll see you in part 4. Peace.